Okay, everyone, I think what we might do is we might get started. It's just after about 3 minutes past 1. I just want to thank everybody for coming along today, and we will start off with welcome to country, and we would like to acknowledge the traditional owners of the land on which we meet today and pay our respects to their elders past and present. Just for housekeeping, everyone, microphones and videos participants will be muted for privacy and timekeeping purposes until the end of the presentation. Please put your questions into the chat box throughout the session, and one of the peer mentors will read the question out when it's appropriate. All responses provided are general in nature and are recording in progress. Sorry about that, guys. I'm not sure what happened there. All responses are provided in general in nature. Encouraged to contact SBHW services for individual advice and specific circumstances. All inquiries about the service delivery should be referred to Angela for follow-up. So once again, I'd just like to welcome everybody to the PMRSO webinar series for 2022. And today we have Kate, who is with us, and I'll pass it over to Brendan now to introduce Kate for our session.
I am off mute. Good. Yep. Hi, my name is Brendan. I'm a peer mentor with SBH Disability Services. Today's session is about capacity building and appointing a decision maker, making decisions for adults who lack capacity, and end-of-life care such as advanced health directives. Today's guest speaker is Kate Muller from Mitchell's Solicitors. Kate holds a Bachelor of Laws and a Bachelor of Arts in History, as well as Master of Laws with honours, all from the University of Queensland. Kate has been practising almost exclusively in succession law with a bit of business law and family law since her admission. Okay, thank you, Kate.
Thanks, Brendan, and George and Blair, thank you for having me. It's such a pleasure to be able to talk about topics that are close to my heart and that I'm pretty passionate about. This is my area of practice, along with obviously the topics I spoke on last time, and this is a huge emerging area, capacity and decision making for adults. It gets very murky and it's very personal for a lot of people. So it can be a very emotional area. So what I propose to do today is to speak to these topics. I first want to talk about capacity. What is it? It's not as clear cut as we all think, not always in any event. And then I want to talk through the ways that a decision maker can be appointed for an adult so that they can make decisions for them. And then I'll touch on end-of-life care and advanced health directives, because that is also a form of enduring document. So right, let's get into it. So what is capacity? So capacity is obviously the ability to make a decision, but it is actually defined in a couple of bits of legislation, the Powers of Attorney Act and the Guardianship and Administration Act, for example. And it is defined at law as being for a person, for a matter, that person is capable of understanding the nature and effect of decisions about a matter, freely and voluntarily making a decision, and then communicating the decision in some way. So when we're talking about a decision, we're talking maybe a financial decision or a health decision. So if you're being asked to consent to treatment or asked about healthcare, then the test for capacity is, does that person understand the nature of the healthcare or the treatment that they're being asked to make a decision about? Are they making the decision about treatment freely and voluntarily, and can they then communicate it in some way that someone can understand? So there's a few presumptions about capacity that exist at law, and the first one is that every adult is presumed to have it. Every adult's presumed to have capacity about every decision that they can make in their life until proven otherwise. That presumption is not actually affected by disability, mental illness, or age. Everyone is assumed to have it. So when we're talking about, say, people who have a severe disability and have done so since birth, you get an odd situation where once they turn 18, they're presumed to have capacity until it's proven that they don't, even when it's clear that they have never had capacity. So that's the starting point. Everyone's presumed to have it. So the responsibility on proving whether somebody does or doesn't once they're an adult is on the person who's wanting a declaration about that capacity. So if it's the doctor wanting to know that an adult has made a decision about their health care and they have capacity to do it, then it's the doctor who must assess their capacity and must basically, and the person who is acting on behalf of the adult is the one either proving or not proving their capacity, depending on which way. Obviously, we need to argue the point. So capacity is time and decision specific. It is assessed at the time a decision is being asked to be made, and it can fluctuate. So people, for example, who slip into a coma, maybe slip in and out of comas, they may have capacity, not have capacity. Dementia patients are a classic example. They have good days and bad days. Some days they have capacity for a certain matter, and sometimes they don't. When we say it's decision specific, what that means is that you can have capacity for some things, but not others. For example, I have capacity to drive a car, but I do not have capacity to read and understand and know the details of the share market. People have different capacity for different things. Most people have the capacity to vote if they, unless they have a severe disability, but they may not have capacity to manage their finances. So capacity varies depending on the type of decision that's being asked to be made. One thing that it's important to realise when we're talking about capacity is we're not assessing an adult's ability to make a wise decision. We're simply assessing their ability to make a decision. So the law makes it very clear that people are entitled to make poor decisions. That doesn't mean you don't have capacity. Sometimes it does in conjunction with other factors, but in and of itself, making a poor decision does not indicate a lack of capacity. Everybody's entitled to make poor decisions, and some people who clearly have capacity make poor decisions all the time, and they're entitled to do that. They have capacity. So there are a series of principles that are set out in a document that I've attached to the end of my slide, a link to it, and I'll speak about it further in a moment, called the Capacity Assessment Guidelines. And they talk about how a capacity assessment is to be made for an adult. And it's important that these procedures are followed so that an accurate assessment of capacity can be made. So I've set out there some of the principles that need to be followed. For example, the adult needs to be provided with information and support so that they can make a decision. That they need to be treated with dignity, their privacy needs to be respected, confidentiality at all times. Even when it's obvious that a person lacks capacity, their permission should still be sought. They're entitled to refuse a capacity assessment if they want to. They need to be fully informed, even if their ability to understand may be lacking. And the third one I've put there that is also very important is that it's important to communicate with the adult directly in making a capacity assessment. There's nothing worse than being in a room and having everybody talk about you and not to you. So it's important that the person assessing capacity speaks to the adult, not via the adult. And that means obviously understanding that different people have different capacities to communicate, and communicating in a way that they understand. So the capacity assessment for capacity is different depending on what it is we're assessing capacity for. So in order to sign an enduring power of attorney, for example, capacity is assessed by the witness who's witnessing the adult sign the document. For QCAT proceedings that I'll talk about in a lot more detail later, that capacity assessment has to be provided by a medical practitioner. So a doctor, geriatrician, somebody with a medical qualification. Capacity doesn't always need to be assessed by a doctor. It can be assessed by, for example, as a solicitor, I assess capacity all the time, capacity to do powers of attorney and wills. And I may not need a report from a doctor. That is a matter for me as a person assessing the capacity of an adult. If I am not sure, then I will ask a doctor to provide me with a report, because ultimately it is a medical decision. Capacity is a medical assessment. It's not a legal assessment, even though it's defined at law. So let's talk more about these Queensland Capacity Assessment Guidelines. If you haven't accessed them and you have an interest in looking at capacity, they're a great resource. They were introduced in 2020, November 2020, when we had amendments made to the Guardianship and Administration Act and the Powers of Attorney Act. They're produced by the Attorney General and Minister for Justice, and they can provide a really comprehensive guide about capacity assessment. So they go through the principles, capacity assessment principles, practical steps to take when assessing someone's capacity. There's checklists in there. There's links to where to find other information. They're really wonderful. And I would encourage anyone who has any questions or issues about capacity to have a look through that document. So they're designed to be used by the person who is undertaking a capacity assessment of an adult, or by somebody who thinks a capacity assessment needs to be made, like a carer or a guardian or a parent or a support worker. Anyone who thinks there's a need for a capacity assessment to be made, then this is the Bible, basically, for capacity assessments. It's a really useful guideline. I've put a link, they're not until the end. I've put a series of links at the end of my slides. It's one of the documents I have linked, so hopefully that link should just work for you. So let's talk about the ways we appoint a decision maker. So back to my initial statement, everybody's presumed to have capacity as an adult. Children don't, because they're children. Until you're 18, you're presumed to lack capacity at law. Once you're 18, you're presumed to have capacity unless it's proven that you don't. So there's three ways to appoint a decision maker for an adult. One is through an enduring power of attorney, and that can occur where the adult has capacity to make financial decisions, personal and health decisions. If you have capacity to make those decisions, you therefore have capacity to do an enduring power of attorney. If you don't have capacity though, so somebody is an adult and already lacks capacity and a decision needs to be made, then there's two ways that happens. One is by appointment as a guardian or administrator through the Queensland Civil and Administrative Tribunal, called QCAT. And the other is an automatic process called a statutory health attorney. That only applies to health decisions, and it is an order of priority as to who can make decisions for an adult for health matters where there's no guardian or administrator and there's no attorney under a power of attorney. Now, I find the terms that we use in talking about capacity and decision making quite confusing. So I hope this helps you, because it helps me to set this out. I've put some relevant terms there because they're really tricky to wrap your head around. Where we're talking about someone who's appointed as a decision maker under a power of attorney, we use the words attorney, financial attorney, health attorney, personal attorney. But where those people have been appointed by the QCAT, they have different names. So a person appointed by QCAT to make financial decisions is called an administrator, and a person appointed by QCAT to make personal and health decisions is a guardian. So hopefully that just gives you a little reference guide to go back to in my slides, because they're the terms that I will be using as we go through this today. So let's talk first about statutory health attorney. So this is set out in the Powers of Attorney Act, and what it does is it allows someone to make medical decisions, only health decisions, for an adult who is incapacitated, where they don't have an advanced health directive in place, they don't have a guardian appointed by QCAT, and they don't have an enduring power of attorney. So classic examples of this are people with quite severe disabilities who've had disabilities all through their childhood, and as an adult, they're never going to have capacity. But there's never been a need to appoint anyone to make decisions because their parents have done it all through their childhood, or their guardian, their carer, so whoever has legal responsibility for them. They can only make decisions about health matters. They cannot make decisions about special health matters, and I'll go through what that is in a few slides' time. The order of priority as to who can step up and make that decision is set out here on my slide. The person has to be an adult, obviously. They have to be readily available and culturally appropriate. And in order of priority, it is first the person's spouse, married, de facto, doesn't matter. The person who has the care of the adult, so that might be their parent, but it might be some sort of other guardian or carer. It's certainly not a paid carer though, that's important. It could be a close friend or relative. And if there is nobody left, there is absolutely nobody around, then the last person, the last decision maker is the public guardian. So that's a situation where there's no one around to make a decision. The public guardian will make a health decision for somebody in that circumstance. Moving on to enduring powers of attorney now. So this is a situation where you have capacity, because remember, these documents can only be completed by someone who has capacity. If you've reached the point where you lack capacity, it's too late to do one. You can't do one. And it is not unusual in my practice to come across people who have signed the document, but they really shouldn't have. They really didn't have capacity to do it. They've just been told where to sign and they've signed. But if we looked a bit closer, they wouldn't have really passed the test for capacity. So let's assume you've got capacity and you want to do a power of attorney. So what they do is they allow you to appoint someone to make decisions about financial matters and personal decisions. Personal decisions includes health decisions. They're regulated by the Powers of Attorney Act, which came into place in 1998. Prior to that, you could only make financial decisions about a person under the Property Law Act. But since 1998, you can appoint someone to make personal and health decisions for you. And the decisions about finances are far more broad under the Power of Attorney Act. So you would use one if you want to ensure that if you lost capacity in the future, suddenly or gradually, so you're in a car accident, you're suddenly in a coma, or you have a dementia-like illness and you slowly decline, and you want at that point in time for someone to automatically be able to step in and make decisions from that moment. They come into effect at different points in time. So where we're talking about personal and health decisions, under the Act, another adult can only make decisions for you if you've lost capacity. Financial decisions are a bit different. You can nominate when you're completing the document when you want the power to begin, and there is the ability to nominate it immediately. So what that means is that you're appointing someone else to make financial decisions for you, even though you have capacity. So it starts right now, even though you've got capacity, and it will continue beyond your loss of capacity. The reason these documents are called enduring powers of attorney is because the power of the attorney endures beyond the adult's loss of capacity. Immediate powers of attorney, I find, are usually used in situations where we have quite elderly people and their children, for example, are already taking them to the bank and making decisions, and they just don't want to be bothered with it anymore. They can still do it if they had to, they just don't want to. So they might appoint someone immediately. An attorney, so who can you appoint? The options for who you can appoint. An eligible attorney is defined in the Act as someone over the age of 18 years, and they obviously have to have capacity. It cannot be someone who was a paid carer for the adult in the last 3 years. Now, a paid carer is not someone who's receiving a carer payment, because that's parents and all sorts of people. We're talking there about a paid care provider. It can't be a health provider, so not a doctor, medical professional. And for financial matters, you can't appoint someone who's been bankrupt, is not a discharged bankrupt. When you appoint attorneys, you've got some options. You don't have to have just one. You can appoint up to 4. They can either act jointly, so everybody together making all the decisions. You can have them successively, one after the other. You can have them severally, which means maybe you appoint 4 and any one of those 4 can make a decision. When you fill out the document, you nominate how you want them to act. And if you don't make a nomination, then they are automatically assumed to have been appointed jointly under the Act. Where you have different people making financial decisions to those people who are making personal decisions, then the form you want to complete is a Form 3, or sorry about my bad spelling, version 4. Long form. I've set it out there so that you can just Google what the form looks like, what the name is, because they're online. But where you have the same attorney appointed or same person making financial and personal health decisions, it's a short form document. So they're different documents. So let's have a look through what sorts of decisions they can make for you. Financial and personal matters are set out. They're defined in the Act. And I've put these links to them over here in case you're curious. So financial matter. A financial matter includes pretty much any matter dealing with an adult's assets that adult could make a decision about if they had capacity. I've listed some of them there. That's not exhaustive. I've sort of combined a few to get them on my one slide. It's a really long list, and you'll see it's very comprehensive. It's dealing with real estate. It's legal matters, so running a legal matter for them. It's paying maintenance and accommodation, paying debts, receiving debts paid to them, carrying on a business if you lose capacity while you're running a business, withdrawing money, depositing money, pretty much anything that you can do right now, that's what your attorney can do as a financial matter. Personal matters include again, not an exhaustive list, but I've picked out the main ones, day-to-day decisions about a person's life. So where they live, which care facilities they'll interact with and services, education. One I want to point out in particular is who has access to the adult. This is one that we argue about all the time in my area of law, where an attorney says you're not going to go and visit mum and dad in the aged care home. We're going to restrict access. That happens all the time, and it's one of the decisions that an attorney can make as a personal attorney. So personal matter includes healthcare, which I've set out there is, it's fairly self-explanatory, but that's the definition under the Act. It's diagnosing, maintaining, treating physical or mental condition carried out by a healthcare provider. It does include withholding life-sustaining measures, so do not resuscitate and turning off life support and things like that. Now, there are some things that they don't include, though. So I touched on it before, a special health matter and special personal matter. So even if you've got an attorney appointed under an enduring power of attorney, they cannot make decisions about making a will. They can't change your will. They can't vote for you, can't line up on voting day and do that. And they can't agree to enter into a marriage for you. The health matters that they can't decide are sterilisation, abortion, and electroconvulsive therapy, ECT therapy. So even if you've got attorneys appointed for personal and health matters, that attorney would still need to go to QCAT if they wanted a decision to be made about one of those matters, and QCAT would have to sanction it. All right, duties of an attorney. So you've appointed an attorney, you've lost capacity, and now that attorney has to make decisions for you. Now, the Act sets out what needs to guide how that attorney is guided to make decisions and the types of decisions that they can make. So there are some general care principles and healthcare principles that are set out at the start of the Act, and they are overarching principles that every attorney needs to follow. So they're to do with supporting the adult's human rights, supporting their ability to make a decision themselves where they can, and maintaining those relationships that are supportive. So not cutting off contact for that adult from all of the people that have been involved in their lives. Healthcare principles are also set out in the Act. I haven't set them out here, they're a bit long and wordy, but if you'd like to, the link to the Act is in the back of my paper. Some of the more, I've set out here some of the duties that are more specific to attorneys. The first one there is to avoid conflict transactions. Now, this is the one that we also argue about a lot. A conflict transaction is where you allow the adult to enter into a transaction that is in a conflict between your duty to them as their attorney and their duties relative to a relative or another person. So I'll give you an example. Conflict transaction is one where you are an attorney for your parent and they're elderly and they need to move into aged care and you need to sell their home, and you sell that house to a relative for undervalue. That's a conflict transaction because you'll enter into a transaction that is putting you at conflict with the adult. One that most people don't realize is even if you were selling that asset at full market value to a relative, it is still a conflict transaction. So there are lots of transactions that attorneys aren't aware of that they need to be careful about. Can't enter into a conflict transaction. They have to obviously act honestly and with reasonable diligence. You can't just sit back and do nothing. They have to consult with all of the other attorneys that are named, even if they're not acting as an attorney. So it's a backup attorney. They still have to. There's still an obligation to consult. Another big one is keeping the person's property separate from the adults. You cannot, as an attorney, mingle your finances with the adult's property. You have to keep them completely separate. You have to keep records and invest wisely. And a big one, you can't give away the adult's property. Another common scenario we see is where people think, oh, look, mum and dad are in the retirement home now. They don't need all this money. It's just affecting their pension because they've got it all sitting there. We're going to get it anyway when they die. How about we have it now? It would be more helpful. That's a big no-no. The adult's money cannot be touched while they are alive, even if it may be affecting their pension. That's just the way that it works. There is an exception for seasonal gifts. An attorney can make seasonal gifts. So Christmas presents and birthday presents for grandkids, and if they put $10 in a card for their grandkids every Christmas, keep doing it. That's completely fine. They also have the ability to maintain the adult's dependence using that adult's money. So obviously, if an adult loses capacity while they have young children, their money can be spent maintaining those children because it would have otherwise if they had capacity. How does an enduring power of attorney end? So you've appointed somebody, you've got this document, when does it end? It ends when either the adult or the attorney dies. It ends when the document is revoked by the adult. Now, it's important to understand that if you've done an enduring power of attorney and you want to revoke it, you have to have capacity to revoke it, just like you had capacity to do it. Enduring powers of attorney are revoked by filling out a revocation form, and it has to be in that approved form. You can't just write on the back of a napkin, I revoke my appointment of Brendan as my attorney. It's got to be in the approved form. It will also be revoked automatically if you prepare a new enduring document that is different. So if I had one appointing George as my attorney and next week I do another one appointing Brendan, then George's document, the one I appointed George under, is revoked. Brendan's is the relevant one and the current one. If the attorney becomes incapacitated, they obviously can't do it. And if they become bankrupt, then they are automatically out for financial decisions. If an adult marries, then the document revokes where it appoints somebody else. So if I'm married to George, but I've done a power of attorney that appoints Brendan, then when I marry George, Brendan's power to act for me ends. Same with divorce. If I then divorce George and he's appointed in my power of attorney, he can no longer exercise that power from that point on. If you're appointed as someone else's attorney, you don't have to do the job. Even if you've accepted it, you can resign. You just give notice to the adult, and that doesn't have to be in the approved form. That can be on the back of a napkin. Having said that, you can only do that if the adult has capacity to do it at the time. If the adult's already lost capacity and then you want out from being their attorney, you can only do that with the leave of QCAT. So you can't just leave them in the lurch. All right, I'm moving on to the next topic now, guardianship and administration. So now we're talking about a scenario where an adult has already lost capacity. They've either never had it through disability, for example, or they've got dementia, or they've had an accident and now they can no longer make decisions for themselves. So guardianship and administration is what we're referring to here. It's the process of appointing someone to make financial decisions for someone, that's an administrator, and then personal decisions. So that's your guardian is appointed for personal and health decisions. So I've just put those terms there again as a little reminder. Someone may be appointed as a guardian and administrator if there's never been a person appointed under a power of attorney, or there was a power of attorney, but all of the attorneys can't act. There's a problem with it. The attorneys are fighting. They're not getting on and they're not doing their job. Or where one attorney really can't be doing the job anymore and they need out. And sometimes that happens voluntarily. One attorney just says, I can't do this anymore. I live too far away. It's too hard. I want to resign. We go to QCAT and can have somebody else appointed. Now, the appropriate place to go to be appointed as an administrator or guardian for an adult is the Queensland Civil and Administrative Tribunal, called QCAT. And I've put their website there. I've also put it at the end of the paper with the other helpful links. I'll talk more about QCAT at the end, but it's a really helpful website. I encourage anybody who has questions about this to get on there and find the decision making for adults site, because it's really helpful. It's designed to be very user-friendly by non-lawyers. So the types of decisions that guardians and administrators can make, guardians are a bit like personal and health attorneys. Any decision about a personal matter, including a health matter, not special health matters, not special personal matters. And administrators is anything to do with their finances and property. I went through before and went through all those definitions of what is a financial matter, what is a personal matter. Those definitions were set out under the Powers of Attorney Act as they apply to enduring powers of attorney. Those same definitions are set out in the Guardianship and Administration Act, exactly the same decisions. So when we're talking about an administrator making financial decisions appointed by QCAT, we're talking about the same types of decisions that a financial attorney could make under a power of attorney. And those same general principles and general healthcare principles apply to guardians and administrators just like they do to attorneys under the powers of attorney. So a guardian and administrator can be appointed in these circumstances. They're set out in Section 12 of the Act, the Guardianship and Administration Act. That's what GAA stands for. It's my abbreviation. So a guardian and administrator is appointed where an adult has impaired capacity, so lack capacity. And I've just made it clear there that the tribunal, the starting point for the tribunal is that they have to be satisfied the adult lacks capacity. If you front up to the tribunal and say, look, George is getting a bit dodgy in his decision making, I think we need to appoint an administrator, QCAT will say, well, prove that he lacks capacity first. Because if you can't prove that, then you need to go away. There also needs to be a need to make a decision about a matter. So an immediate need to make a decision, and that might be where the adult's health and welfare is about to be adversely affected. They can be appointed without an appointment, rather. If we don't appoint somebody, then their adult's needs aren't going to be met or their interests aren't going to be protected. So they're the sort of three tick the boxes that QCAT has to be satisfied about. So I've just put down the bottom there that it's not uncommon for QCAT to refuse to make an appointment if there's no need. And a common scenario that we see often is where you have a child with a disability and they turn 18 and mum and dad say, well, we've been making decisions all this time because we're parents, but now they're 18 and they're presumed to have capacity. We need to be formally appointed as a decision maker. You march off to QCAT and QCAT says, look, we'll appoint you as an administrator to look after finances because they've got bank accounts and stuff, but we're not going to appoint you as a guardian. You've been making their health decisions all your life. You still will as a statutory health attorney, no need to do it. And often QCAT will say, no, we're not appointing you because there's no need to do it. In talking about who can be appointed as a guardian and administrator, it's a bit similar to appointing attorneys. They've got to be over 18, can't be the paid provider or health provider. And for administrators, they can't be bankrupt. You can, if nobody else is appointed, then obviously public guardian and public trustee are the appropriate people for guardianship and administration. When deciding who to appoint, there's another checklist that QCAT look at, section 15, which are the appropriateness considerations. So when looking at whether it's appropriate to appoint a certain person as a guardian or administrator, they'll have a look at whether that person has the appropriate skills and is compatible with the adult, whether their interests align, whether they conflict, and whether they're accessible to the adult. No good appointing somebody who lives in another country or isn't going to be around. Talking about who can make that application to have an administrator or guardian appointed for an adult, then the public trustee and the adult guardian can make an application. But to be honest, the Act actually provides that any interested party can make an application to QCAT. And the applications that I've seen made are from pretty random sources. Healthcare workers will do it all the time, aged care workers, hospital staff, services, disability support services do it all the time. Sometimes it can be quite random. It can be a next door neighbour. I've seen a next door neighbour do it. I've seen a receptionist in a medical practice do it because they thought a patient, the relationship wasn't quite right. Anybody can refer a matter to QCAT about anybody, and that's enough for QCAT to then investigate and be interested. So I've set out here the duties of a guardian administrator. They're exactly the same as the duties of an attorney under a power of attorney. I've just given the different references for the different act, but you'll see I've actually underlined and italicized a few of them. That's where the duties differ to an attorney under a power of attorney. So the power to keep records. If you appoint an attorney under a power of attorney and then you lose capacity, that attorney doesn't have to prove those records to anyone. They don't have to keep an accounting unless there's a problem and someone asks. They should, because it's a wise thing to do, but they don't have to produce them. Whereas if you're appointed as an administrator under the tribunal, there is a requirement generally that you produce them every 3 years or every 5 years or whatever period of time the tribunal requests. So in other words, you will be regularly audited. The other difference that I've got, the two down the bottom, are that the tribunal can order professional administrators to be appointed. So trustee companies can be appointed, and obviously the public trustee and the adult guardian, the public guardian, can be appointed as well. Another big one is reimbursement for reasonable expenses. If you're appointed by the tribunal as someone's guardian and administrator, you are entitled to be reimbursed by the adult for the reasonable expenses incurred in acting as that attorney, guardian or administrator. If you're appointed as someone's attorney under an enduring power of attorney, you are not entitled to any form of compensation or remuneration. It's a love job. It's a love job because you have the ability to say no. Right back when you were appointed, you've got the ability to say, no, thank you, I don't want to do it. Whereas if you've gone to the point of being appointed by QCAT, then you're appointed by a judicial body, and therefore sometimes there's less avenue for you to pull out. So let's talk about the practicalities of applying to QCAT. So you have an adult, there's a need to be appointed as an administrator and a guardian for a person. How do you do it? First step is get onto QCAT's website, because it's, as I mentioned, wonderful, and it steps through all of these procedures. So QCAT is a tribunal that's designed to be used without lawyers, so that costs are kept down, because lawyers are expensive. And we're talking here about people who don't have a lot of funds most of the time. And so particularly if it's not a contested matter, then the proceedings are very informal, and you can generally turn up and apply yourself and act for yourself. Sometimes matters are complicated legally, and it is appropriate to have lawyers. If you want a lawyer, you have to have the tribunal's leave. So you have to ask them first, can I have my lawyer? And then the tribunal says yes or no. So the first step is to complete an application form. If you wanted to apply to be somebody's administrator or guardian, then you complete what's called a Form 10 application. You also need to have a report from the doctor. So that's the health professional report. And if you're applying to be someone's administrator, you need a financial management plan. So you have to set out what sort of money is under administration for the adult and what you plan to spend it on. Once you file that application with QCAT, you'll be assigned a case manager. So that there is a period of sort of pre-hearing preparation. Case manager will contact you. They'll say, great, thanks, we've got your application. They might let you know if they need more information. It could be sometimes that the doctor's report's not sufficient. If there are other parties who need to be notified, then the tribunal will notify them. You don't need to notify them. The tribunal will do that for you. So that might be a situation where you're one of 3 adult children and you're applying to be mum or dad's guardian. Your siblings will need to be notified. Even if they don't want to be a party of it, they will need to be notified. And those interested parties then have the ability to submit material to the tribunal because they might object. So the tribunal's now got all its documentation. Everybody's filed all of their stuff. Everybody's there. The next step is that you'll be notified of a hearing date, and it will be assigned to you, and then you need to attend at the hearing. The adult who lacks capacity is encouraged to attend if possible. If they're able to attend and they're not going to be distressed about it, then they're encouraged to attend where they can. Once the hearing has been conducted, the tribunal will usually hand down a decision there and then. All of the parties get notified in writing after the fact. Now, that decision may not in fact be, yes, you're appointed, or no, you're not. Sometimes the tribunal member will want more information. They'll give directions. Sometimes they'll say, I need to hear from sibling number 4, or I need to hear from the doctor further. There's a whole stack of reasons why the matter might be adjourned, in which case there will be another hearing, and you sort of just keep going down the line. So that's the process for a straightforward application to be appointed as somebody's guardian and administrator. We have gone through this process a lot. We assist people through this process a great deal. Generally, where someone has a child with a disability who's turned 18, they now want to be appointed as a guardian administrator. Usually those applications are not contested. In other words, no one's going to fight you on it. And if that's the case, you turn up to the tribunal, you have the hearing, it all goes very smoothly. You'll never get turned down because it's not contested. Nobody's fighting you. The tribunal, just so that you're aware, can make lots of other decisions as well about attorneys and guardians and administrators. So they can review an appointment. If someone's already been appointed as a guardian or administrator or an attorney and someone else has an issue with that, then they can apply for QCAT to review that appointment. You can seek permission to withdraw if you've already been appointed as an attorney and they've lost capacity, or you've been appointed as an administrator and guardian, you don't want to do it anymore. You can also just seek advice and directions from the tribunal if you are not sure about making a decision for an adult. You can seek an interim order. So these are urgent orders and they're temporary. There needs to be an immediate risk of harm to the adult, or you're not going to get on an interim order. This is possibly the biggest issue we are experiencing with QCAT at the moment. Is a very big behemoth of an organisation in terms of its workload. Very few people doing that workload, particularly in the space of decision making for adults. If you file a normal application and it's not urgent, you will wait about 8 months to get a hearing date. If it's not urgent and you ask for it to be heard urgently, and you better hope somebody's about to die, because they will not hear it unless it's extremely urgent. They're just that overworked and understaffed, unfortunately. One of the other orders that the tribunal can make is consenting to a conflict transaction. So I mentioned before, it's a breach of an attorney's duty to enter into a conflict transaction, but sometimes it's the right thing to do, in which case QCAT needs to sanction that. And declarations of capacity. So if you have an attorney appointed for somebody or an administrator, but then that person, the adult, regains capacity, you need another declaration to say they are now declared to have capacity, and it removes that appointment. And obviously you need the tribunal's permission if you want to make a special healthcare decision for an adult, for example, and that includes experimental treatment, medical research, and then those ones I mentioned before about sterilisation, abortion, electroshock therapy are also ones. All right, let me work through advanced health directives quickly. They sit under the same sort of jurisdiction as enduring powers of attorney. They are an enduring document. They allow you to appoint someone to make decisions if you have capacity. So you've got to have capacity to do it. If you don't have capacity, too late. It allows you to give directions about life-sustaining treatment, blood transfusions, and then other healthcare decisions, anything you like, really. Mostly they are used for life-sustaining treatment. It commences only if you lose capacity. And for life-sustaining decisions, it commences only in certain circumstances I've set out there. So basically you're terminal, you're going to die within 12 months, or you're being kept alive through that extra treatment, you're persistently vegetative state, you're permanently unconscious, and you're not coming out of it. That's when the decisions you've made about life care, end-of-life care, kick in. Again, these documents die when the adult ends, or if you revoke it while you have capacity. I just want to touch on how these documents interact with each other. So if you have appointed an attorney to make personal and health decisions for you, and then you've done an advanced health directive, and you lose capacity, end of life care, all of that jazz, you're in that situation, the decisions you've made under the advanced health directive will override your personal attorney's ability to make a decision where they're inconsistent. So your attorney cannot override what you've put in your advanced care directive. But a question I'm asked all the time is, do doctors really follow these documents? Yeah, I've had experiences, but generally the position at law is yes, but they won't do it if the decisions you've made are not consistent with good medical practice, or they don't benefit you. If your directions aren't clear and it's uncertain, or where medical advancement has now meant that you could receive treatment and you could be cured or at least treated, and it's not going to, you're no longer at end of life as a result. So you can't put in the document, if I get an infected big toe, turn off my life support. Clearly doctors will ignore you, and that's what we're talking about there. If you've made a silly decision or it's not good medical practice, doctors will override you, and it does happen all the time, I'm going to tell you. I just want to make a few comments about some other things that often are raised in this space. Do you have to become a guardian or an administrator or an attorney to interact with Centrelink and NDIS? You may already all know the answer to this. The answer is no. You can be a Centrelink nominee and an NDIS nominee without needing formal appointment. If you have attorneys, administrators and guardians that fight, they don't get on, generally we're off to QCAT to have everybody fight it out. And I'll tell you now, everybody's going to get removed. But there is another avenue for health matters, and that is to ask the public advocate to intervene. The public advocate will actually mediate where people have different views about healthcare for an adult that lacks capacity. If you are concerned about an adult's welfare and they've already got a guardian or attorney appointed and you think they're not doing a very good job, we need to have a look at that. Again, public advocate will investigate for you. You can just make a complaint. Anybody can make a complaint to the public advocate to say, I think we need to look at this. You can apply to QCAT to review it. But as I've mentioned there, often QCAT will just remove everybody. It's not always very helpful. And again, just to reiterate, anybody can refer a matter to QCAT for investigation, even if you have the slightest inkling that something doesn't seem right. Another grey area that's emerging a lot is just to address this is, what if you've got an adult that's vulnerable, but doesn't necessarily tick all the boxes for impaired capacity? So they can manage their finances and make day-to-day decisions. But if somebody came up to them and said, hey, do you want to invest in my dodgy business venture? It's a really good idea. And they jumped at the chance, and because they're vulnerable and they are probably a bit too trusting, where do those people fit? The test for capacity, if we go back to my first slide, was that an adult has to enter into transactions freely and voluntarily. So if they're not making a decision freely and voluntarily, technically they do lack capacity. But I will make a note that proving that is very difficult at law. Proving that somebody's is vulnerable to the point where they lack capacity is very difficult. It comes down to a matter of evidence. But they are often the people who kind of slip through the cracks a little. They don't really fit into any of the normal boxes. So they are probably the most difficult matters that we experience in this area of law. Elderly people still have capacity, really vulnerable to making everybody around them happy. And that makes them very vulnerable. All right, there's my helpful links. Hopefully those links, you should just be able to copy and paste or click on them. I've also put another one there that I didn't refer to, which is the responsibilities of an attorney under a power of attorney. That's a document that the Office of the Public Guardian has put out. It's really helpful. So hopefully those links will be helpful for you. With QCAT, if you get onto the QCAT site, I've just directed you there. You need to aim for the section that says decision making for adults with impaired capacity, because QCAT do a lot of other things. They do dividing fences and minor debt disputes and things like that. You want to aim for decision making for adults with impaired capacity. All right. Do you want me to just run through these questions, Brendan or George, or are there others?
We do have one, Kate, that's come
Sure.
from David. I think it's in the chat there. You might be able to see it yourself.
I think I have to look. Oh, there we go. Sorry, bear with
Yeah.
me. I just have to go to another screen to do that. If this will let me. Here we go. What about a situation where a service provider wants funds from an NDIS plan? Do they have to be accountable to the administrator? Yes, if there's an administrator appointed. So if you've got an administrator appointed, they, in my experience, your experience might be different, but in my experience, if there's an administrator appointed, they are usually the person that's also organising NDIS funding, and they're the NDIS nominee. So that person is naturally the person that is interacting with the support providers and the care providers. So the short answer to your question is, I guess, yes. Where a service provider needs funding, then the administrator is the appropriate person to approach for that.
Thanks for that, Kate. And I think you've just pulled up a couple of questions on your slides there. You'd like to answer those for us? Sure.
So this is a good one. When an elderly couple is involved, do you have to take the different solicitors so they're not influenced? No, you don't. It's actually helpful to have them both in the room because their affairs will be so intertwined. What we don't do, so as solicitors, when we see elderly couples, in fact, anybody, and we're talking about doing a will or a power of attorney, what we will do is ensure that no one else is in the room. So an elderly couple might be brought in by their adult child, and we will ask that adult child to wait in reception while we take instructions so that there is no allegation of any sort of undue influence. But the couple themselves, they're fine to be in the room together. The exception to that rule, and it's only happened less than a handful of times for me personally, is where it's not a good relationship. One member of the couple clearly lacks capacity and is being manipulated. That gets a bit tricky, but they need to be in the room together in order for me to discern that, and then I can take steps to ensure that I am assessing capacity without the influence of that other person there. Hopefully that answers that.
Thanks, Kate. I think we've got one more there as well.
Legal and NDIS along with care guardianship. So they're quite separate. Legal administration and guardianship for an adult is quite separate to NDIS. You can be an NDIS nominee and you can be a Centrelink nominee, and you don't need to be someone's attorney or guardian or administrator in order to do that. So they're quite separate functions. So you don't need to be all the same person. But invariably, as I mentioned before, if there is a guardian or administrator or attorney appointed, usually that is the person who's interacting with NDIS and social services.
Thanks for that, Kate. I do have a question myself I'd like to ask right now. You were talking earlier about the lawyer, if they were asking for a lawyer and the QCAT or the will accept it or not. Why would they do that? Is there a legal requirement that they do that, or is it what's behind that? When
would you have a solicitor present? Essentially, if it's a really complex matter. So the two types of matters where I've been involved in, where we've had lawyers involved, one has been where there has been what is called undue influence. So there are presumptions that arise if you're appointed as someone's attorney and you do certain things as that person's attorney. A presumption arises at law that you've unduly influenced the adult to do something, and that becomes a legal argument that will be contested. So the person making the application will have seen their solicitor, and then the person responding will want their solicitor involved as well. So that's quite a heavy legal matter. There's a lot of law involved in that, and therefore the lawyers get involved. The other type of matter where we've had lawyers involved are where someone has been appointed as an attorney or administrator and they've not done the right thing, or there's an allegation they haven't done the right thing. They seek legal advice about their role, and that then becomes a contested hearing where there's allegations of inappropriate actions and evidence needs to be led. And in those scenarios, the hearing becomes like a mini trial. We call witnesses, people give evidence. All the rules of evidence are different for the tribunal. It's not quite as strict as for Supreme and District and Magistrates Court, but it runs similarly. So in a short answer to your question, George, is for really complex matters.
Great, thank you for that. Brendan, did you want to ask any questions? And did anybody else in the group want to ask? We might try to unmute you one at a time if you've got a question, and then we'll go from there.
Thanks, George. I don't have any other questions, but yes, if anybody's got any questions, I guess we're going to unmute the platform so people can ask.
Yes, I'm just trying to find how do I unmute everybody so people, yeah. I will just go around and unmute people if they'd like to try and see if they can unmute yourselves, and you can ask a question away. But please keep it to one at a time. That would be great. So I think you've got the capacity, guys, to unmute yourselves if you'd like to do that and ask a question. David, did you have another question?
Yes, I do, George. Thank you. I just was wondering about the vulnerability notion. With hydrocephalus, there can be impacts on perception of information and the behaviour of other people, which can get very interpretational. So would that be a point which you're consulting with a solicitor about how to go through QCAT and so forth, or with particularly with entering into contracts?
Yes.
Like a financial arrangement.
Yep, absolutely. So if there's a question or a concern, then yes, I think you're right, David. And I think another good starting point is the person's doctor, the treating doctor, and that might be a psychiatrist or some sort of specialist, or if they're elderly, a geriatrician, because there should be a medical professional involved in that person's life who can express a view about that, and express a view as to whether the vulnerability is to the degree that their decision-making ability is impaired, and it's appropriate for somebody else to assist them and step in.
Thanks, Kate, and thanks for the question, David. Anybody else like to ask a question? Go ahead. Naomi, did you want to ask a question?
Oh, I did. I typed one in, but my question was, I don't know if Kate's the right one to answer it, but we have elderly parents and they've been going along great, but at what point do you know that my husband's power of attorney and, you know, I help, at what point do you know, do you intervene? Like they both think they're fine, and it's going to happen with my parents as well. At what point do you exercise things? Because we don't want to take over for them. They're independent, they're proud. We can see that the wheels are falling off a bit with respect to cleanliness and, you know, meal prep, but they're still pretty good. But it's just, my husband and I talk about it all the time. Like, at what point do you get bossy? And it's a really awful situation, but it's really hard to know, you know. It is hard. At what point, how do you know? And what's the first step when the time comes when you both think we actually have to do it now, especially if there's resistance? Like, it's actually really tricky.
Yep. Very good question, Naomi. And that is happening a lot, and I see it a lot, and it's a very common scenario, particularly with elderly people, where the government's push is to keep people in their homes longer and to get them care in their homes and to not move them into facilities unless they need to. So, I mean, they're being told you should stay at home, but they may not necessarily be the appropriate place for them. What I have found essentially, Naomi, is the law can only do so much. So you could be appointed as someone's attorney or administrator or guardian, and legally you've got the ability to do it, but timing it and determining when to exercise that power is not a legal decision. It's just when is the time right? And sometimes where they are so unwilling to accept help, and I hear you, I have a parent who will not, for the love of her life, accept anyone to clean her house or bring her meals, so she just eats ice cream. She refuses, and what it comes down to is they're entitled to make a choice. It's not a good one, it's not an appropriate one, but if putting in carers and getting people in causes them more distress, at some point you've got to let it just play it out. There will come a tipping point. There will come a point in time, unfortunately, and for most people, elderly people, it's when they have a fall. When they have a fall, or you know, my grandmother used to catch taxis, and when she started giving the wrong address to the taxi driver in our small town, that's when we knew, if you can't get yourself home and you're going to be dropped off somewhere you don't belong, that's a problem. So where things like that and they become unsafe, that's when I think it's critical to really step in. And unfortunately, Naomi, sometimes what has to end up happening, if they're not willing to do it, is you're in a scenario where you've just got to put them in care. And that's horrible. But if it's the best thing to keep them safe and they're not willing to see it, that's unfortunately where you end up. The best case scenario is that with lots of talking and chatting and raising it and making it normal, that they come to understand that it isn't so bad. Even visiting places, you know, look at this lovely aged care, you know, this retirement, look at all the services. You can play bingo, you can go on bus rides. Sometimes, you know, they really come around to it, but it's hard, and there is no point. It's whenever you think that they're no longer safe.
That's good. That's good advice, because I've just had the discussion about, I go up probably a week in every month to North Queensland. It's expensive. It's time consuming. I've still got kids at school, but I just had an awful, not argument, but just upset one of them about Meals on Wheels. One's perfectly willing and gets that they need it. The other one, the mum, obviously is insulted because she's always cooked, but she doesn't know how to cook anymore. And it's really tricky. And so my husband and I just were talking about it. I got back and I was upset, knowing that I can't be upset because she doesn't know what she's doing. But we were just saying, maybe we just have to leave them to eat, you know, just pumpkin, or a bit like you were saying with ice cream with, you know, one of your relatives. It's hard, but maybe I just have to not have that argument anymore and just accept that. But it's hard, because you know that Meals on Wheels will at least give them a balanced meal. We'll give him a balanced meal, which is what he needs. But I think maybe I just have to pull back a bit. And as you said, maybe something obvious happens, like they can't get themselves home, or they have a fall, which is awful to think of, but it's it's a defining moment then.
Yep. I have heard of where I once I heard of a situation where an elderly couple just refused to have anybody come over, no one to check on the cleaning, and it was a bad state. A relative bought them a pet, oddly enough, and then said, well, now we need to have someone come around and walk the pet and take care of the pet because you can't. And it was just somebody else would come to the house twice a day just to check on the pet, and would check on mum and dad. So that was an extreme case where I thought that was a bit of out of the box thinking, just to have somebody popping around to see them. But you're right, it's a difficult negotiation. I find I'm having conversations like, gee, if I were in your position and I was retired and I had, money, I would be getting HelloFresh and Meals on Wheels. No way I'd be cooking. You're mad. Can you get it for me? If you're not going to get it for you, can you get it for me? That's reverse psychology, kind of like interacting with young children. Sometimes it works, sometimes it doesn't.
Yeah. Look, I actually suggested, the funniest thing you said, that I actually suggested the dog to the husband and said, I think they need a dog, a little dog, just to from the pound, $300 or whatever, and we'll just buy it. And he's gone, that's a nightmare, but because they're on a farm and there's snakes and everything. But that was the one thing I could think of to say, that we need to get, we need to check on this, and we keep them busy and stop them stressing about their health and what they can't do. But I know he's not quite with me, and I mentioned it to them, would you like to go to the pound and look at some dogs? No, they just get eaten by snakes, and they do, unfortunately. But but look, it's that's good advice. A precipitating moment, there'll be a moment. At the moment, it's just sort of trying to sneak in Meals on Wheels and trying to sneak someone in. Won't hear of someone coming to look at the cleaning because they're not doing it properly. But it's actually quite hard to get someone too, even though they're approved for. It's very hard to get anyone to do anything, including put the bar in so they can get off the toilet, everything.
Oh, dear.
Yeah, it's quite hard to get someone in, but we'll just do that next time we go up. But
yeah,
Thanks,
it's a tricky one, Naomi.
Thanks, Naomi. Much appreciated. Great question.
Thank you.
Thank you for your great question. Kate, we do have one more question that's just been put up in the chat.
Yep. Chat. Let me find a chat. Sorry, I have to look this way. It's gone on my other screen for some bizarre reason. Okay. Your advice for parents of children turning 18, history of intellectual disability and impaired decision-making capacity. Do they go through QCAT process even though it may be deemed that the appointment of guardian is not necessary? If they already Centrelink an NDIS nominee, do they still need to do it anyway so that QCAT? Great question. And the answer is no, you don't need to. So QCAT's preference is actually that they are happy for parents to continue to fudge it. Once a child with a disability turns 18, if you can continue to make decisions, you're still got possession of their bank account and doing everything for them, keep doing it. I have often found that nobody really challenges that appointment until the parents are elderly and they can actually physically no longer keep doing it, or it's becoming tiring and another adult sibling is taking over. That's the point in time at which we often find ourselves applying to QCAT. Because mum and dad have managed to do it all their lives. So you don't need to go to QCAT. And in fact, I would encourage you not to unless there is a need to do it. QCAT will probably turn you away because there's no point. Keep doing it. If you can fudge it, keep fudging it. QCAT's happy for you to do that unless there's a need for you to be appointed. And as I said, you don't need to be appointed in order to interact with NDIS and Centrelink. So you can just keep doing what you do. I hope that answers your question.
Thanks for that. David, you've got one more question? Just unmute yourself, David.
Just in relation to my last question about the capacity.
Yep.
If a person was to enter into a financial contract that they wanted to happen, but the administrator was there and saying no. Do they have an avenue to actually say, well, I want this to go ahead? Legally,
no. Legally, if an administrator is appointed, then QCAT has made a determination that they lack capacity to make that decision themselves. So the appropriate person to make it is the legal administrator. But so in order for the adults to sort of be able to make that decision themselves, they'd have to have a declaration of capacity made so that the tribunal says, okay, you've got enough capacity now to make your own decisions. We will remove the administrator's appointment. So legally, no, the administrator gets to make that appointment. I do find that there's quite a space there's quite an avenue for mediation, not really formally, but there are some services that provide it, like the public advocate will do it. Places like Relationships Australia will actually provide mediation for this sort of thing. Just how do we do it? And David, that is actually one of the focuses of the new amendment since 2020 is the real push now with decision making for adults is trying to empower adults to make their own decisions where they can. So the administrator should, in the scenario you've just described, if it's not a completely colossally stupid decision that's going to injure them and harm them, they should be letting them do it. They should be empowering them to make decisions where they can, even if those decisions are not ones that the administrator personally would make. And that's what we're trying to do now with this area of law, is make your own decision if you can, or at least have as much input as you can. And administrators should pay attention to that. Whether they do or not is difficult. They should.
Yeah, because that's this is where I see the grey zone.
Yep.
For
absolutely
people with hydrocephalus.
Yep.
Thanks, Kate.
And just to follow on from that, David, one of the biggest, I guess, downfalls with this area is there's not a lot of enforcement mechanism in QCAT and the public advocate. The most that QCAT can do is remove someone. That's it. And they can make them pay back money if you can prove that you've misappropriated an adult's money. But there's no penalty for being a bad attorney. There's no, even though we say you should, you should have the adult making the decision where they can, there's no repercussion if you don't. So it's not, there's no enforcement, as it were. Sometimes that's really unfortunate.
But there's no scope either to negotiate with somebody who's been appointed, because their power is absolute at the moment.
I mean, they should be open to negotiation. Absolutely. They should be listening to the adults and following their decisions as much as they can. But whether they do or not, I mean, who's going to prove that they're not legally? By the time you get before QCAT, you've waited your 8 months to get a hearing date. It's the wheels of this behemoth turn very, very slowly, unfortunately, with QCAT. So you're better off sort of informal mediation and more informal means. In the first instance, anyway.
Thanks, David. Thanks. Great question. And Kate, thank you for all those questions and for your session today. Anybody else like a quick question before we finish off for the day? Sorry, anybody? No, okay. Kate, can I just get you to stop sharing if you don't mind?
Sure can.
And then Brendan, I might hand it over to you, mate, just to finish off for the day and just give a thanks to Kate for her time and everything. Just like to unmute yourself, mate.
Keep forgetting to do that. Yeah, very much appreciated that you accepted our request for this presentation, Kate. Your time over the last 2 sessions brought a lot of value to the community, and it's very much appreciated.
It's been my absolute pleasure. Thank you very much for having me. I hope I've been a bit helpful and added a bit of value. Thank you.
So, guys, we're not quite finished yet. Just we'd like to just quickly chat about our next seminar, which is next month. So I might just hand it to Brendan to bring that slide up and take it over.
Yep. So our next seminar is on the 10th of May. So we have our guest speaker is Dr. Michelle Swain, senior paediatric neuropsychologist, and Amy Willis, who's a clinical paediatric neuropsychologist registrar from Queensland Children's Hospital. So the seminar will run from 1 till 2 p.m, same as our other sessions, and it will focus around childhood hydrocephalus, its implications and strategies to cope with the condition. There should be registration forms and things like that ready on the website for that seminar soon as well.
Thanks, Brendan. So once again, Kate, thank you so much for your time over today in the last session. Lots of information to go through and lots of links to do some research and try and get our legal matters in order. But
thanks, George.
just really greatly appreciate it. Thanks for everyone for turning
Pleasure.
up today as well, and listening to Kate and being with us today. And we hope that we catch up with you next time on our next seminar, and have a great day and look after yourselves, and thanks very much.